Okay, guys, we are into still the red packet. This is the second review I've given in terms of video. I've looked over the previous video to see what's going on. We're going to have to adjust your volume because I am a loud talker, so depending on that. And I obviously have learned that I look better looking from a further distance and better looking is a relative term anyway. But anyway, we are still into the red packet. If you want to follow along within the material, the 2 pages on personal intentional torts with assault, battery, false imprisonment, stuff like that. The 8 on front and back pages of those 2 pages is what we're going to go over with. And we're on page 116 of the study guide. Okay. The last thing we talked about was assault and battery, and we talked about Texas has far-reaching gun laws. The Texas jury would be much more sympathetic to a gun user. Once we finish with false imprisonment in a little while, I'm going to go over some scenarios that might be good for storyline scenario questions. But I wanted to, before we get to assault and battery only, I wanted to add in false imprisonment, and then we're going to do the other ones as well. Okay, false imprisonment. This is on page 116 of your study guide. We need to go over the basis of this definition once again. It's an intentional holding or detaining of a person within boundaries if a person is harmed by such a detention. And this detaining or confinement could be physical restraint, the use of force to restrain someone against a person or family's property, person or person's family or their property, or you retain someone in custody when they're supposed to be released. So if we're intentionally holding someone or detaining that person and they are harmed by that detention, whether it be through physical restraint or a threatening force to restrain yourself, others, your family, or your property, then this could all fall under false imprisonment. And depending on how you do it, that could also be assault and battery as well for the previous 2 ones that we've studied also. And then you retain someone in custody when they're supposed to be released. We're going to talk about more along that lines of police officers and or with also shopkeeper's privilege in a little while. But let's go over this. Person is harmed by such a detention, detaining someone within the boundaries using physical restraint, forced restraint, and stuff like that. Okay, when we talk about the physical false imprisonment, false imprisonment. Once again, it's intentional. They meant to do the act. That act resulted in harm to another. Hold on one moment. Didn't realize the dog was in the room. Okay, anyway, so let me give you this scenario. Say we were back on campus and it was a regular non-coronavirus and all that stuff, and you were taking an exam. Say it was exam 1. And during exam 1, SWIM locked all the doors to where you could not get out of the room. Now, as you're taking your exam, those first 15, 20, 30 minutes, no one even knows that they are locked in. No one knows. So has he committed a false imprisonment against you? Okay? No one knew about it, but are you detained? And are you harmed by such a detention? Well, the thing is, yes, you are being detained because you can't get out, but you are not harmed by such that detention. Therefore, there is no false imprisonment. Now, if the doors are locked and you can't get out for hours, and now maybe there is a false imprisonment, definitely so. And think about it, the crime of kidnapping would be the tort of false imprisonment. So if you're kidnapped and being held against your will, then that would be definitely false imprisonment on a tort aspect or civil side aspect. But when we talk about that, if you're not harmed by SWIM locking those doors, okay, then it is not going to fall under false imprisonment, okay? You must be harmed. Now, that harm could be physical, or in certain cases, it could be mental as well. But you were not physically restrained, there was no threatening force to restrain you, and you weren't harmed by such a detention, therefore there would be no false imprisonment. Now, if you were locked in that room, say, I locked the doors Friday night, knowing you were in there, locked them, and you couldn't get out until Saturday, Sunday, or maybe even a week later if we shut down during the coronavirus, then yeah, you're definitely harmed by such a detention, and you could theoretically sue for false imprisonment as and I being the tortfeasor in that situation. But think about it that way. If a false imprisonment occurs, you have to be harmed by such a detention. Now, in terms of who is harmed and stuff like that, that's a different story. Every time it's going to be a different story on what is a reasonable person think. But you have to think like Swim sometimes. If Swim locks you into a room and you don't know that you're locked in, you don't even know anything about the doors being barred or where you can't get out, then there's no harm in terms of the detention. However, are you being detained? Yes. Are you being detained, but you're not being harmed? Once you try to get out, that can rise to the level of a false imprisonment. Now, the next thing we need to talk about is shopkeeper's privilege. Shopkeeper's privilege is basically under common law. Okay, that is judge-made law, so to speak, where the merchant, whoever it is, has a right to reasonably detain a suspected thief on their premises for a reasonable amount of time. So, what is a reasonable detainment? And then what is a reasonable amount of time? You would argue that if a shopkeeper or shoplifter is caught shoplifting, a shopkeeper would have the right under this common law shopkeeper's privilege to detain you until the police arrive. That is assuming that the police officers are told in a timely manner and they show up in a timely manner. So say you get, you're leaving Walmart and the siren goes off, okay? That could be simply because something didn't get scanned properly. So you wait for somebody in usually a dingy blue shirt to arrive. Sometimes it's an elderly person, so it takes a little bit longer. They come, they check your receipt, check your bag, see if there's no shoplifting, and they let you go. That's a reasonable detainment. So you're being detained, whether or not you were physically detained, you are being detained by the shop to see whether or not a potential shoplifting has occurred. Now, what if they actually see you shoplift and you leave the store with the items and they grab you and hold you and bring you back? What would be a reasonable amount of force that can be used for assault and battery to detain someone? And what would be a reasonable time period, reasonable detainment for that suspected thief by the shopkeeper themselves? Okay? So you have to ask yourself, if you are going to be detained until police arrive, say they put you in a closet or a room with a security guard, they lock the door and they put a security guard by the door behind you. So now you're locked in a room. If it's done for 5 minutes while the police arrive, probably a reasonable detainment. There's no false imprisonment. The only thing you probably have to worry about there is how did they get you into that thing? Did they use reasonable force or whatever to get you into the closet? There may be assault and battery there, but not false imprisonment. Now, if they forget for whatever reason to call the police or the police don't arrive and they keep you there for hours upon hours, and maybe you've only, quote, shoplifted, even if you even shoplifted, you've only got a minor thing, then probably that would be more unreasonable detainment. And then the shopkeeper wouldn't have the right to detain you for that long, and it could arise to the level of false imprisonment. I hope that makes sense. Because the shopkeeper has a right in most states. Texas has more criminal penal code law and stuff that is associated to it, but the shopkeeper has a right to detain someone as long as it's some reason. To me, a reasonable amount of time would be until the police arrive, as long as the police were done in an orderly manner. If they forget to call the police and they leave you in for hours, then yeah, that probably arises to more of a false imprisonment claim. Now, the other one is you retain someone in custody when they're supposed to be released. Say, for instance, there was a case a long time in San Diego in one of the county jails or something like that in San Diego, where they put a suspected thief into a wing that was being renovated. No one knew he was there, and no one forgot to do the paperwork and everything like that. He was left there with nobody went and checked on. No one knew where he was. He was left there for like a week. He had no food or water, so he started to drink his own urine. Would he be able to likely sue for false imprisonment? Definitely would probably be there, because that was a physical restraint against him retaining someone in custody when they might have been released. And since they weren't notified, they were definitely, he sued and won millions of dollars against the city of San Diego for false imprisonment. And that would have likely arise to a false imprisonment claim. All right, so now that we've done those three, before we move on to the other elements of the other different types of torts that we have, the first three, let's go over some situations that we might have. We've talked about, grabbing someone from behind, grabbing their breast for, a battery, or just pretending to do it for a potential assault. But what if my wife and I were to get into a fight and she's maybe 110 pounds soaking wet, and look at me, I'm buff, so, I'm 6'4", 260 pounds. Okay, no, I'm not. but I'm not really afraid of her when it comes to, in general stuff about our situation. So if she was to come and get mad at me and try to hit me, I'm probably not going to be in a reasonable amount of fear. However, if she takes this butcher's knife, say she's in the kitchen, we have an argument, and she gives me this look like I'm going to come slit your throat, now, or she even has a gun and pulls a gun on me, now, regardless of her being 5'3", 110 pounds, and me being, say, 6'3", 250, is irrelevant. Now, this is going to be a reasonable expectation of fear for that 6'3" guy. The gun would be a reasonable expectation of fear. So now I'd be in fear. Whereas I wouldn't have been in fear without that knife or gun. So now it's a rise to the level of assault. If she uses the knife or something like that against me, that would be a battery. She uses the gun, shoots me, misses, an assault, but not a battery. If it hits me, we have a battery. What if she shoots the gun, misses me, but it ricochets off, the refrigerator and then embeds in my shoulder? Now we have an intention to do the act of shooting, and it resulted in harm. That would be a battery as well. She can't say, oh, I meant to hit the fridge. I meant to scare you. Well, there's the assault, but I didn't mean to hit you. That doesn't matter. She meant to shoot the gun, and that act resulted in harm to another. So if some person is randomly shooting a gun and it ricochets and hits someone, they can't say, oh, it was a tortfeasor. I didn't mean to do it. I didn't mean to hit that person. Therefore, there's no assault. There's no battery. No, there is a battery because the person intended to shoot the gun, and that resulted in a ricochet that hit them. I hope that makes sense. Okay? So when we have that stuff, what if she was holding the knife or holding the gun and said, you are not leaving until we finish this conversation? That could arise to a false imprisonment claim. And our kitchen's really kind of small. And it's ironic because she can't cook for anything, but she'd have a knife in that kitchen to begin with. But that would arise to a potential assault. If she uses the knife against me, potential battery. And if I'm not allowed to leave because she's holding a gun against me or a knife against me, that could arise to a false imprisonment claim as well. All right? Okay, so when we talk about false imprisonment, we talk about the situation where, say, Swim locked the door during the exam, or you lock the door until the police arrive. Police arrive in a normal situation, that's probably not going to be false imprisonment. But now let's talk about, like question number 1, where there's a robbery. Someone, pulls a knife and takes away, or tries to steal your purse, takes away your purse, or takes away the blind man's wallet. Okay? The blind man, or say it's an elderly lady, after the purse is stolen, pulls out the gun and shoots the robber. Okay? Would this, and say the robber dies, would the robber's family be able to sue the elderly lady or the blind man or whatever for shooting the gun and killing the person? The question then becomes is, were they able to use a reasonable amount of force? Absolutely. To protect yourself, others, a reasonable amount of force. You can use deadly force if it's first used against you. So would the elderly woman, would she be able to use deadly force to protect her, say, purse when it's been stolen by turning around as they're leaving and shooting it? I would argue no. Generally speaking, they would not be able to do that. But remember, Texas juries are sympathetic to gun users, and you're going to have a jury that's going to say, oh, in that certain situation, a reasonable woman that's elderly would be scared. And therefore, there's definitely an assault, and maybe they're scared for their life. They're going to use deadly force against them. They may be able to win that lawsuit and defend themselves as a tortfeasor against assault and battery because they were already, a robbery had already been committed. Now, to an average person, maybe not an elderly person, and the person's already left with the purse, to turn around and pull out a gun and then shoot later on, that might not fall to the level of battery as well. But if they're holding the gun on you until you give you the wallet or something like that, but it only lasts a couple of seconds, does that arise to a false imprisonment? Yes, you're being detained, and there's someone's using a force or threat against you. That could arise to false imprisonment. But if it happens over like a 2, 3 second, 5 second period where you hand them your wallet, you get your wallet out and you hand it and toss it to them and go, well, then that probably isn't going to be false imprisonment, especially if you're in an open airway. Okay? And I think he has a question where something like that occurs, and it occurs right across the street from a police station or from a police officer and something like that, who was just 60 feet away or something like that. it probably wouldn't arise to the level of false imprisonment. Now, say there is a bank robbery, they lock the doors, they keep you in, they shoot a gun, a bunch of spray bullets going everywhere, don't move, as they rob the bank. Well, definitely we have an assault because we're in reasonable fear. We have no battery if they just do it up against the ceiling, but we do have a potential assault. We are now being held against our will through the use of a gun. That would probably fall as false imprisonment as well. Okay. Now, if one of those bullets ricocheted off the ceiling and then hit somebody during that spray of bullets, then we could say that is battery as well, correct? But if nobody had been hit by a bullet, there's probably no battery, just assault, possible false imprisonment, but not the battery. Okay. So for false imprisonment, what you need to know is intentionally holding or detaining a person within a boundary if they are harmed by such a detention. That could be emotional or a physical harm. Physical restraint, threatening a person with physical force or restraint against themselves, person, family, property would all fall under definition of false imprisonment. But remember, a reasonable detainment has to occur. And when it comes to shopkeeper's privilege, you're going to have to determine what is reasonable and what is not reasonable. Okay. The next thing we have is infliction of mental distress. And this should be at the very bottom of that last page of personal intentional torts in your red packet. And we're on the top of page 117 of your study guide. Now, I'm going to give you the definition. Before we go any further, I'm going to give you a storyline and make you think about it, and think about it in terms of, would this be infliction of mental distress or not? First of all, the definition is intentional conduct. So it's conduct that's intentional, and everything's intentional so far, by a person that is so outrageous that it creates severe mental or emotional distress in another. Is outrageous or extreme conduct beyond the bounds of decency. So if he gives you a storyline on the exam, and he says, and he makes it so outrageous in the storyline, so beyond the bounds of decency to an average person, then you need to be thinking immediately about this thing. If in the multiple choice answers it says, this is considered by the jury to be outrageous or extreme conduct, or this is beyond the bounds of decency, he's giving you a little hint that maybe infliction of mental distress needs to come into play. Okay? So we have outrageous or extreme conduct that causes outrageous or extreme conduct beyond the bounds of decency that is so outrageous that it creates severe mental or emotional distress in another. Now, if you look on the study guide right below that definition, it gives all the Texas elements associated to it. Now, I'm not big into the Texas elements. There's a couple of things about Texas we'll go over a little bit later. But knowing the general elements, if he gives you a storyline that happens in Texas, maybe you need to know the word choices. But I would focus on the idea behind intentional infliction of mental distress. What are the key words? Intentional, obviously. Conduct is outrageous, outrageous or extreme conduct beyond the bounds of decency that creates mental anguish or mental distress in another person. Okay? So let me ask you this. I'll give you a storyline. Say I was coaching my son's soccer game. He's about 9 years old. Maybe he'll throw into the room here and you'll see him in a picture in a little while or something like that. But if I was his soccer coach and during the game, he is wide open right in front of the goal, the goalie's on the ground for whatever reason, it's an easy goal within 3 to 4 feet of the goal, and he completely misses the goal. Kicks it out of bounds, kicks it over the goal or whatever. And I just pull him off the field. I'm not yanking, I'm not physically pulling him off. And I just get into his grill. I just say, you're a worthless piece of shit. I can't believe you fucking missed that goal. How the fuck did you miss that goal? You are horrible. I cannot believe you're even genetically mine. I'm going to have you tested. I'm going to have me tested. This is ridiculous. You are worthless on a soccer field. And I was to say this all to a 9, 10-year-old. And he was to get so scared, he was to pee in his pants. And then I was to make fun of that as well by talking to him about that. Would this arise, and could the person committing the tort be sued for infliction of mental distress by my son for what I did? Would the average person say that is outrageous or extreme conduct beyond the bounds of decency? And if you would say yes, would you say that is intentional infliction of mental distress, or would you say no if given that kind of a storyline on the exam? Okay, think about it for a second. Okay, the answer is no. It probably would not arise because if you look on page 117, kind of in the middle of your study guide, It says it must be more than just obscene or abusive language. Well, obviously, what I said to my 9-10-year-old son was obscene and abusive language, but I have freedom of speech, so it probably wouldn't arise to intentional infliction of mental distress, even if his emotional embarrassment led to him peeing. Because if you look at C right above that in the study guide on page 117, usually requires manifestation of physical harm, either a heart attack or stroke. That could be insomnia, that could be malnourishment, it could be a heart attack, it could be a stroke, it could be migraine headaches, it could be any number of things that go from mental to the physical aspect of it. And it says it usually requires manifestation of physical harm. Usually requires does not mean always requires, so you need to note that for the test as well. It doesn't always require to get to physical level, but if he gives you a storyline in which it's outrageous or extreme conduct beyond the bounds of decency and it goes from mental to physical, then you're probably going to be looking for that as a mental distress case. Now remember, it can be abusive or obscene language, so in this situation, I would be able to defend myself as a tortfeasor from this tort because it's got to be more than obscene or abusive language. Now, if he gives you a similar story about, say, an adult chastising a child or a judge in a position of authority chastising someone and going well beyond that stuff, it would not be infliction of mental distress because it can't be abusive language. Freedom of speech, First Amendment comes into play. All right. So, if you look at the questions on infliction of mental stress, if you look at C, heart attack or stroke. Let me give you an example of something that I watched a few weeks ago, and it always reminds me of this. There's a Criminal Minds episode, if you're a Criminal Minds fan, that was like season 2 or something like that, in which a college student was kidnapped, raped, and murdered by 2 assailants. Okay, but what these assailants did is they videotaped the rape and murder, and then sent a copy of that videotape DVD to the parents of the kid, the girl that they raped and murdered, and kidnapped, obviously, to do so. Okay, when the parents put the video in that they thought it was from their daughter, when they put the video in and watched it, the dad ends up dying from a heart attack while watching. Would this arise to the level of assault, battery, false imprisonment, and infliction of mental distress on what these 2 assailants did? Well, the assault, obviously, there was a fear with the kidnapping, rape, and murder. Battery, obviously, if there's a murder, there's going to be physical assault and all that stuff as well. So we have assault, battery. If it's a kidnap, then obviously false imprisonment. They're intentionally holding someone detaining, and the person is harmed by such a detention. So a false imprisonment. So against the lady or against the college student, we already have assault, battery, and false imprisonment that those people could be found guilty of and under tort law. But then sending the video to the parents, would that arise to infliction of mental distress? Would you think that is outrageous or extreme conduct beyond the bounds of decency to videotape someone getting raped and murdered and sending that to their parents? And if that parent watched the video, got so mentally anguished from it, emotional distress, that they had a heart attack and died, then that would go from mental to physical. That would arise to pretty much all the characteristics of mental distress. And you could argue that tort could be applied by the parents as well. All right. Now, on the last things on the mental distress, swim is not a huge portion on dates. Chronological order, maybe. There's a couple of things on dates that you need to know. One's in chapter 7 a little bit later on. But there has been a question that has recently been told to me that what tort was created or not recognized in the court system in Texas until the 90s. And that is intentional infliction of mental distress under F. This is a tort gap filler, can only be used when other torts do not suffice, not recognized by the Texas Supreme Court until 1993. So I would know that specific date for the exam. We were one of the last states to do so, and successful cases of intentional infliction of mental distress are rare in Texas. Now, Thailand's Automobile versus Walters. I have heard this being a multiple choice option. I don't know if that was if it dealt with infliction of mental distress or not. So I'll put Thailand's as a tier 2 case. Tier 2 meaning it's on the exam, you might need to know it. Thailand's Automobile was an infliction of mental distress case. It was a rare victory in Texas dealing with infliction of mental distress. It's not a successful case in Texas very often. And it wasn't recognized in Texas in the court systems until 1993. I would note all those things. Okay. Now we are on that second page of the personal intentional tort that should have invasion of privacy and defamation, and then two more at the very bottom. Now we're talking about invasion of privacy. Now, I talked about earlier about how assault and battery can be very closely entwined with one another, maybe even throw in a little false imprisonment as well. I threw in the infliction of mental distress on that kidnapping thing just a little while ago. But that assault and battery can go hand in hand. And there could be 6, 7, 8, maybe even more scenarios. One girl said a few semesters back that she had like 11 or 12 questions on her exam where they were just assault and battery. And out of 50 questions, that's a significant portion for just 2 different torts. Okay? Invasion of privacy and defamation of character can go hand in hand, and they're just as big sometimes as assault and battery. So these 2 that we're about to go over next are probably some of the bigger ones that you need to go over as well. All right? Now, the first thing we're going to talk about is invasion of privacy. Then we're going to talk about defamation and how they interlink with one another on certain situations, and you need to be prepared for that. The first one is invasion of privacy. The definition is an invasion into a person's right to solitude, an unwarranted public exposure. Unwarranted does not mean unwanted. Unwarranted means they didn't have a right to do it. So, an invasion of a person's right to solitude, an unwarranted, not should have done, public exposure. And then if you look down at D towards the very bottom of page 117 on your study guide, it must have a public disclosure of a private fact that is offensive to an ordinary person. So if you combine A and D together to get a better definition of invasion of privacy, invasion of privacy, invasion of a person's right to solitude, an unwarranted public exposure of a private fact is offensive to an ordinary person. So if a public disclosure of a private fact was given about a random person, by an ordinary person, and they found that disclosure of that private fact to be offensive, that could arise to the level of invasion of privacy. Now, do public figures get as much protection as do average normal U.S. citizens? No, nowhere near the same level. So, not all U.S. citizens receive the same invasion of privacy protection, and you need to know that for, say, answers A and B, the difference between those. Celebrities are not, public figures are not going to receive as much protection. Now, they do receive some, and we'll get to that a bit later on. Public figures use a lot, but not all of their rights to privacy. Okay? Now, when it comes to invasion of privacy, there are certain types. The use of a person's name or picture without their permission for advertising purposes, that is C1 on the bottom of page 117. If you use someone's likeness or image without their permission to advertise for something, that is likely going to fall under invasion of privacy. So if I was to take someone's photo from exam 1 and put it on our website, and I didn't get permission to do that, that would likely be an invasion of privacy unless we had a rule or a situation where they gave permission to do so. They didn't give permission, that would likely be an invasion of privacy. Intrusion into a person's solitude, that would be an illegal wiretap of work, going into someone's closet, going into someone's file cabinet, going into someone's diary, someone going into someone's nightstand next to them and finding a bunch of different things. Those would all be an intrusion into a person's solitude, an illegal wiretap. Okay? The public disclosure about a person which is offensive or objectionable, publish a person's credit report. If I was to find in your closet or in your file cabinet, if I was to go to, say you were having a party after the exam's over, and you invited me because I helped you out so much, and you were like saying, you know, I got bored of this party because look, y'all are all a bunch of college students. I've gotten over the extreme kegging and stuff like that from college. I did that the first 3 sophomore years of my life. I don't need to do it again. But then I went through your closet, or I went through a file cabinet. I found your credit report. And on your credit report, it said you had a 500 credit score, which is really bad. And I told everybody about that. That would likely be an unwarranted public exposure of a private fact that you, as the average person, would deem objectionable for me to disclose that to people. You could then sue me for invasion of privacy. What if I found in that same file cabinet a copy of your medical records? And on your medical records, it had that you have syphilis, gonorrhea, herpes, chlamydia, HIV. You had all these things. Okay? And I told everybody at the party that this guy has all these sexually transmitted disease, herpes, chlamydia, gonorrhea, syphilis, HIV, all those things. If you didn't give me permission, and that was something that was your right to that's a public exposure of something that was a private fact that you object to, then you could sue for invasion of privacy. Okay. Now, public figures do not lose all their rights to privacy. And this is on page 118 of your study guide. Public figures do not lose all their rights to privacy. They still have a right to privacy to the details of their private life. So, say you were to publish information. I think I made a Bernie Sanders question earlier on when we did the questions at the beginning of the packet. But what if you were to say something about Trump's private life? Does he have a right to privacy to the details of his private life? Even as a public figure, he does. He would have probably just as much to the details of his private life as you or I would. Public figures do not receive as much protection, but in certain aspects. So if you were to publish details of Trump's private life, certain details of their private life, he could probably sue for invasion of privacy just as much as an average citizen could do if you did the same thing to him or her. So if I found Trump's detailed list of syphilis, gonorrhea, or something like that, and I published it, he would probably be able to sue me for invasion of privacy. Now we'll get to defamation later, but invasion of privacy he could sue because even his details of his private life are going to be somewhat at least protected. Okay? So public figures lose much, but not all of their rights to privacy. I would be ready for a situation in which a public figure, whether it be like a George Clooney, could be a President Trump question, it could be an Obama question if it's an older question on the exam, or any kind of celebrity. Remember, if we keep details of their private life, they have some protection that they wouldn't normally have, or that other people do have as well. Okay. Now, when it comes to points to remember on G on page 118, unwarranted does not mean unwanted. Unwarranted means you didn't have a right to do it. Unwanted means, you didn't want it to happen. There's a little difference between those. The next one is public records render information public. So it's a matter of public record. Say you have a criminal history, and I find in your nightstand or in your file cabinet your copy of your criminal history, and I tell everybody that it's a criminal. That's a matter of public record, so that wouldn't necessarily be near as much of an invasion of privacy because the public record renders information public and therefore not subject to invasion of privacy. Okay? All right. The next one we have is defamation. Defamation requires, let's go over the definition of defamation, and then I'm going to talk about the 3 elements. We need 3 elements in order for defamation to occur. It's a publication of false information or false statement that tends to injure a person's good name or reputation or cause the public to hold that person up to public contempt, hatred, or ridicule, and causes him or her to be shunned or avoided. And then it talks about the different types, libel versus slander. We'll get in that in a little while. But if you think about it in terms of defamation, it has got to have 3 criteria. The first one is it must be a false statement. If it is true, it is not defamation. It could fall under invasion of privacy still, but it's not defamation. So if I make a true statement about you that is an unwarranted public exposure, you would not be able to sue me for defamation and win and I would be able to protect myself as a tortfeasor, but I would not be able to win against invasion of privacy, but I could win against defamation. It must be false. So if it's true, it's not false. It must injure a person's good name or reputation. Now, between number 1, false statement, and number 3, as I consider it, good name or reputation, you have to have element number 2, which isn't really listed there as much, but it makes sense. To get from 1 to number 3, how do we go from there? To go from a false statement to injuring a good name or reputation, you have to have that information communicated to a third party. So the 3 things for defamation that we need to know: 1, it's got to be intentional. All these are intentional torts, still personal intentional torts. It's 1, got to be false. 2, it's got to be communicated. It's got to be overheard, seen, or whatever by a third party. And that must cause your good name or reputation to be injured. Now, however you want to put those 3 in order, it doesn't really matter. On the exam, you need those 3. Because think about it this way. If my wife and I were to have a fight while the kids are at school, okay, there's no school right now for the kids, but say we were in a forest or whatever, and we were just yelling and screaming at each other, we were making defamatory statements about one another, false statements about everybody, and all sorts of stuff. Okay? And this false statement, no one else besides us in the house or in the forest or wherever, we were the only two people that heard it. Then her good name or my good name was not injured, or the reputation was not injured, because even though those statements were false, no one overheard it. So in order for the good name or reputation to be done, it must be overheard. Now, if we had this argument in the backyard and all the neighbors while walking their dog overheard it, then maybe one of our good name or reputation has been injured. And if the statements were false, then we have defamation of character as well. Okay? Now, in terms of defamation, there is a term which is not in the study guide, not in the book, and if SWIM doesn't talk about it in class or on the videos now, then you're going to have a problem with it on the exam possibly, and it's called defamation per se. Now, this is a possible multiple choice option. What is defamation per se? Defamation per se is a form of defamation that is so bad that it injures your good name or reputation. You don't even have to show proof of injury or good name or reputation. It's automatically assumed. And there's a question in the back of the study guide in chapter 5, one of the questions we're going to go over a little bit later. But it's so bad that it injures your good name and reputation regardless. Okay, it's still got to be overheard by and broadcast by a third party. But you don't have to prove your injury to your good name or reputation. It's automatically assumed. Okay? So, if I was to say something that was so bad, and the four ways that defamation per se occurs is, if you say someone has a criminal record and they don't, that is going to injure their good name or reputation automatically. Number two, okay, is if you make a false statement about their profession or their abilities in the professional or business setting, that is going to injure their good name or reputation automatically. That's number two. If they have a sexually transmitted disease, chlamydia, gonorrhea, herpes, syphilis, HIV, all those things, and they don't, that be injury to your good name or reputation automatically assumed. It would injure your good name or reputation. Remember, all these got to be false, okay? And then number four, serious sexual misconduct. Serious sexual misconduct. For example, what if, and there's a story from like 2012, 2014, and you can Google it. There's a guy in Florida, and if you want to Google, Florida man has sex with pit bull. And it turns up his, basically his jail inmate picture. It's one of the scariest looking men. I will never think of myself as the ugliest person alive because he's still alive. But anyway, if he had sex with a pit bull in his front yard, okay, if other people watched him and or videoed him, could he sue for invasion of privacy? The answer is no, because he didn't have a right to a person's right to solitude. It wasn't an unwarranted public exposure because he did it in public, correct? And it's not defamation because he actually had sex with a pit bull. But what if I was to get in a fight with you and I told everybody at the top of my lungs that you've had sex with a pit bull? Okay? Now, if you haven't, then that is a false statement that is automatically considered to be serious sexual misconduct. For the average person would think that's serious sexual misconduct, and therefore it would cause good name or reputation to be injured. Defamation per se would say that is going to be defamation automatically per se. You don't even have to prove that the injury, good name, or reputation occurred. If it is done through recorded speech and or written, i.e. blogs, internet, newspapers, something like that, that is libel. Libel is the recorded speech and or written aspect of defamation of character. Slander is the spoken form or unrecorded spoken speech would be it. So if I tell everybody at a party that you have sex with pit bulls and it turns out it's not true, you could sue me for defamation per se under slander because it's automatically assumed good name or reputation be injured and it's a false statement. Now, if it's true, it's not defamation. Now, how you found out that information may be an invasion of privacy, but it's not defamation. So if you had sex with a pit bull, defamation of character did not occur, okay? Now, if after telling everybody in the story or in the party that somebody writes it on their blog and says, oh, my neighbor had sex with a pit bull, and now it's on the blog, they, if it's false, could then sue for libel because that is going to be the recorded speech, the blog, that's going to be written form, that's going to be libel. So you would sue the person at the party for saying it for slander, assuming it's false, and it would be libel for the person if it was put on a blog or something like that. Okay. Now, for public figures, in order for public figures to sue for defamation, they must show malice. They must or should have known that the statement was false, make the statement anyway, and i.e. basically intend to injure. You intended to injure them. So if it's like an Obama or a Donald Trump or a George Clooney, because they're a public figure, in order for defamation of character to occur, not only does it have to be false, injure good name or reputation, but it also must be made with malice. So if say Trump was to sue you for defamation for whatever, one, you have to know, is it spoken and or written libel or slander, but then you also have to know that Trump would have to show malice, okay, in order for defamation to occur. Okay, we're going to take another break, start at the next video when we get to the defenses.